All persons having any business before this honorable court now draw nigh. Give your attendance and you shall be heard. God save the Queen.
Admission of lawyers. Bishop Samuel Biggett.
May it please the court, I move that Bishop Samuel Biggett be admitted as a lawyer of this honourable court.
That Bishop Samuel Biggett be admitted as the lawyer of this court.
Madeline Isabel Bowden.
May it please the court, I move that Madeline Dowden be admitted as a lawyer of this honourable court.
That Madeline Isabel Bowden be admitted as the lawyer of this court.
Susanna Jane Hoffman.
May it please the court, I move that Susanna Jane Hoffman be admitted as a lawyer of this honourable court.
That Susanna Jane Hoffman be admitted as the lawyer of this court.
Megan Kent.
May it please the court, I move that Megan Kent be admitted as a lawyer of this honourable court.
That Megan Kent be admitted as the lawyer of this court.
Elaine Paling Kwan.
May it please the court, I move that Elaine Paling Kwan be admitted as a lawyer of this honourable court.
That Elaine Paling Kwan be admitted as the lawyer of this court.
Jordan Chuk Yun Lee.
May it please the court, I move that Jordan Chuk Yun Lee be admitted as lawyer of this honourable court.
Let Jordan Chook Yung Lee be admitted as the lawyer of this court.
Carol Lynn.
May it please the court, I move that Carol Lynn be admitted as lawyer of this honourable court.
Let Carol Lynn be admitted as the lawyer of this court.
Cesar Lopez Mazpez.
May it please the court, I move that Cesar Lopez Mazpez be admitted as a lawyer of this honourable court.
Let Cesar Lopez Maspes be admitted as the lawyer of this court.
Lungaka Nonteta Bedla.
May it please the court, I move that Lungaka Nonteto Mbetla be admitted as a lawyer of this honourable court.
Let Lagaka Nonteta Mabella be admitted as the lawyer of this court.
Gillian Rose Moran.
May it please the court, I move that Gillian Rose Moran be admitted as a lawyer of this honourable court.
Let Gillian Rose Moran be admitted as the lawyer of this court.
Maria Peter Morris.
May it please the court, I move that Maria Peter Morris be admitted as a lawyer of this honourable court.
Let Maria Peter Morris be admitted as the lawyer of this court.
Patrick John Rafferty Orme.
May it please the court, I move that Patrick John Rafferty Orme be admitted as a lawyer of this honourable court.
Let Patrick John Rafferty Orme be admitted as the lawyer of this court.
Rita Sayed.
May it please the court, I move that my wife, Rita Sayed, be admitted as a lawyer of this honourable court.
Let Rita Sayed be admitted as the lawyer of this court.
Andrew James Williams.
May it please the court, I move that Andrew James Williams be admitted as a lawyer of this honourable court.
Let Andrew James Williams be admitted as the lawyer of this court.
Benjamin Peter James Wilson.
May it please the court, I move that Benjamin Peter James Wilson be admitted as a lawyer of this honourable court.
Let Benjamin Peter James Wilson be admitted as the lawyer of this court.
Mitchell Craig Worthy.
May it please the court, I move that Mitchell Craig Worthy be admitted as a lawyer of this honourable court.
Let Mitchell Craig Worthy be admitted as the lawyer of this court. It will be necessary for the purpose of an oath or affirmation that all those being admitted today please stand up but remain in your current places. Could all admittees please stand?
Bishop Samuel Biggett. Madeline Isabel Bowden. Susanna Jane Hoffman. Megan Kent. Elaine Paling Kwan. Jordan Chuk Yun Lee. Carol Lynn. Cesar Lopez Maspes. Lungaka Nompeto Bedla. Gillian Rose Moran. Maria Peter Morris. Patrick John Rafferty Orme. Rita Sayed. Andrew James Williams. Benjamin Peter James Wilson. Mitchell Craig Worthy. Do you severally swear or declare and affirm that that you will truly and honestly conduct yourselves in the practice of a lawyer of the Supreme Court of New South Wales, and that you will faithfully serve as such in the administration of the laws and usages of this state according to the best of your knowledge, skill and ability. Be safe, so help me God, or I do.
So help me God. So help me God.
Please be seated. Now that the formal part of the proceedings has ended, I'd like to warmly welcome you to the Supreme Court of New South Wales. Present with me on the bench today to my right is Justice Davies, who is a judge of the Common Law Division, and to my left Justice Ball, who is a judge of the Equity Division. Together we constitute the court that has, in exercise of its jurisdiction, admitted you to practice. As we gather here today, I would like to begin by acknowledging the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respects to their elders, past, present and emerging. We recognise the long-standing and enduring customs and traditions of Australia's First Nations and acknowledge with deep regret the role our legal system has had in perpetrating many injustices against Aboriginal and Torres Strait Islander people. To all the new lawyers here today, welcome to the legal profession. Today is a day for celebration. You've worked extremely hard to get here, through caffeine-fuelled nights, trying to solve obscure problems, reading countless wafer-thin pages of textbook, and more cases than you can hope to remember. Don't worry, it doesn't matter if you forget 90% of them. You have entered a world of eggshell skulls, encountered the mysterious reasonable person, and have understood that the Constitution consists of so much more than the vibe of the thing. In becoming a lawyer, you have today joined a centuries-old profession with ancient origins. The custom of advocates swearing an admissions oath dates back to the 12th century. This court first admitted lawyers to practice in 1824, and by 1830, the names of lawyers were entered onto rolls in this state. You have now become part of this tradition almost 200 years later. Perhaps for some of you, or for your family and friends, that's how long it feels like you've been studying. On that note, I'm also pleased to welcome those with you today or watching on live stream. For many of you, the support of your family and friends has been invaluable. No doubt, they have also often been on the receiving end of your finely polished skills of argument and persuasion. I do hope you take the time to thank them today. The oath of affirmation you have made today is a serious one and deserves solemn regard. Whether you work in private practice, at the bar, in a community legal centre, or in an entirely different field, you should be known for your honesty, your integrity, and your commitment to justice. It is an acknowledgement of this weighty responsibility that we observe today's unique formalities, including the moving of lawyers, swearing of oaths, and even our somewhat strange choice of fashion. On a lighter note, on one occasion some years ago, a young member of the audience asked if we were doing Santa photos after the ceremony. Regrettably, I had to tell him we were not. However, although we mark this occasion with formality and tradition, not everything in the legal profession remains unchanging. You'll be unsurprised to hear that last year we had to adapt quite a bit. COVID-19 meant a rapid shift to increase use of virtual courtroom setups and technology to ensure access to justice continued in the midst of a pandemic. Things didn't always go smoothly, as those with me on the bench can attest to. There have been real difficulties to grapple with in terms of open justice, effective communication, and fairness to participants. And occasionally a lawyer might even get stuck behind a Zoom kitten filter. But for all the challenges we faced, the impetus is greater than ever before for us to prioritise flexibility and accessibility. Better use of technology and increased working from home arrangements have profound implications for how our legal system interacts with many people, including those in rural and remote areas, those with a disability, medical conditions, or carers' responsibilities. As the newest members of the profession, you are at the forefront of innovation in the law and have a unique opportunity to see through changes so that justice is done openly and equitably. There are, of course, other changes that deserve attention. When we think of the diversity of the legal profession, we encounter the duality that we have come very far and that much still needs to be done. Though women were originally not permitted to practice, since 2018, women have made up more than half of all solicitors with a practising certificate in New South Wales and currently make up 63% of solicitors under the age of 30. Women occupy many of the most senior positions in the law, including, of course, the Chief Justice of Australia. However, women continue to face challenges of representation, including amongst judges of this court and amongst barriers in speaking roles in appellate courts, particularly the High Court. It is heartening to see that the local court of New South Wales has almost achieved gender parity amongst magistrates, but we must not be complacent about these issues. There are other noticeable diversity concerns that we must face head-on. Aboriginal and Torres Strait Islander people and people from diverse cultural backgrounds continue to be alarmingly underrepresented in the legal profession, and particularly within the judiciary and the ranks of senior counsel. We must also be alert to barriers to the profession from people from less privileged backgrounds. Law should not be a profession for the wealthy, and the idea that students may be dissuaded from studying law by the cost of a law degree, which this year has again increased, or because of other systemic issues, is troubling. Not just this, but we will only achieve a truly diverse profession when barriers to advancement are broken down and people from different backgrounds are properly supported in a collegiate and inclusive environment free from harassment and discrimination. These issues are fundamental to a just and transparent legal system and to the legitimacy of the rule of law. We need diverse representation amongst advocates and judges so that all people who become involved in our justice system can be properly heard and fairly engaged with by a system reflective of the broader community. Despite these challenges, there is real scope for change. There is far greater diversity of background amongst junior lawyers than those who have been around for as long as me. And you only need to look around at the people in the courtroom and then at the paintings on the wall to see that this is so. You are in a unique position as new lawyers who are entering the profession at a time when more than ever your words and actions are having impact for good. You are being heard and taken seriously when you agitate to correct injustices, whether it be speaking out against unsustainable working cultures, sexual harassment or bullying within the profession, unfair laws, or systemic failings affecting our society's most vulnerable. I urge you to continue to speak up for these things. They do matter. You are the future of the profession and will steer the direction it will take. As a lawyer, you will also need to make difficult ethical decisions at times. With regard to our personal characteristics, lawyers have been the butt of jokes for centuries. Cynics would say there are, of course, only a handful of lawyer jokes. The rest are true stories. Jokes aside, you must use the tools you have developed to think critically and not compromise on your fundamental duties to the court and the administration of justice and other ethical duties which you must uphold. Now that you're lawyers, you can get paid to argue instead of just arguing for free. Of course, there is a lot more to it than that. You're an advisor, a problem solver, a mediator, and an advocate for the marginalised. As you go about your day-to-day work, remember that you're not merely dealing with the law in a vacuum as a series of abstract concepts, but law as it applies to people's lives. For this reason, you must strive to deliver legal services competently and fearlessly with courtesy and integrity. Justice Gageler, before he was a High Court judge, once said, "You must be prepared to give the same answer to the same questions for the same reasons, no matter who asks the question or for what purpose or in what context the asking may occur." This is foundational to upholding the rule of law. For those of you who will practice law, the way you communicate information to others will have profound consequences for access to justice. One of your roles as a lawyer will be to make law accessible to others, sometimes by deciphering legal complexities, other times by deciphering poor legal drafting, and sometimes both. One thing you will regrettably strike throughout your career is legislation which seems carefully crafted with the object of ensuring no one can understand it. Your task is not just to understand it, but to explain it clearly to those whose rights and interests are affected by it. As lawyers, we must not keep the law locked up as something knowable only to us. A client reading your advice should be empowered to understand your meaning, not mystified and confused. So be clear and concise in your writing and your speaking. Plain English is powerful. Consider, do I really need to say aforementioned or herewith? Must I sprinkle in that Latin phrase? Should I really use double negatives, tautologies, and wordy clauses that take up a whole page? I would suggest the answer to those questions is obviously no. The best advocates make their point simply and succinctly. Some of the most experienced lawyers and judges could also use that reminder. You've probably picked that up from wading through old cases. I also want to speak about failure. I would not be surprised if there are quite a few overachievers and perfectionists in the room today. Even so, at various points of your career, you will inevitably make mistakes. Some minor, some perhaps more serious. When you do make mistakes, your commitment to honesty, integrity, and the administration of justice means that you must take responsibility, correct what you can, and learn from those errors. You must fail at times in order to grow. I myself have made many mistakes over the years, far too many to remember. But what is important is that you try not to make the same mistake twice. Even as Chief Justice, my decisions have, on occasions, been successfully appealed to the High Court. At that stage, I'm usually obliged to tell myself that the High Court is never wrong. But in fact, at times, even dissenting High Court judgments become the law. Finally, I want to emphasise that your mental health is extremely important. This may sound unexpected at this type of ceremony, but the law is not everything. There may be times when you feel overwhelmed, burnt out or distressed. If you do, you should not be afraid to seek professional help or to take a step back when you need to. Always remember that the law is a collegiate profession, and in times of difficulty, the support of your peers will prove invaluable. Although you might find it hard to believe, I was admitted quite a long time ago. I lost my first case, and I lost many more after that, probably more than I won. But throughout my 35 years in practice, my colleagues in my chambers, I could always be counted on to share my disappointment at the unfairness of the verdict, the slight tactics of opposing counsel, and most often, I regret to say, the obtuseness of the judge or judges before whom I was appearing. I hasten to add, I do not include any of my fellow judges on the bench in that comment. On behalf of all the judges of the Supreme Court, and particularly those sitting with me today, I once again congratulate you on your admission and welcome you to the legal profession. The court will now adjourn.
Will it stand?